I told my
And you
probation.
didn't make it on the 26th. So then they reschedule you for March 28th to give you a chance to make it, and you still didn't make it. We're gonna go back on the record and 2022 CR 11444, State of Texas versus Jonathan Bolden. Mr. Bolden, it's the court's understanding that you realize that the range of punishment is up to 2 years in the prison. Is that correct? Right. And are you still going to be pleading true to violation of condition number 4?
Well, I'm put it like this. I could honestly say, yeah, but in actuality, I did because I tried to.
I don't know. Here's the thing. With violations and motions, sometimes people will say, yes, I did not report. Hypothetically, I did not report yesterday. And maybe the reason why they didn't report is because they're in the hospital and they can't report. Technically and legally, you did not report. So you would be pleading true. And then you would say, but Judge, I have an explanation as for why I didn't report. So with regards to violation of condition number 4, are you still pleading true to that? All right. Do you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 2 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4? All right. And state you're still waiving the other allegations?
Yes, Judge.
All right. The court will find violation of condition number 4 true. Is there an agreement?
Continue.
All right. So does anyone have any witnesses?
We don't, Your Honor.
All right. So I'll hear argument defense.
Your Honor, my client, as evidenced by his plea, did plead true, did miss reporting in March of 2024. On March 20, through discussions with my client and with probation, he missed his report day of March 26. He called the office on March 28th to try to explain he's homeless. He lives on Ridman Road. Probation knows that he's homeless. He didn't have a bus pass. He made every effort to be there on March 28th. Did not make it by 5 p.m., but he did appear on April 1st, where a warrant had already been issued and he was arrested. He has every intent of complying with probation. Homelessness obviously being a big struggle, as well as many physical disabilities. He reports to me that he's been working to get full insurance to cover issues with his legs and his heart. If the court would recall, I think he was set 2 weeks ago. He was in the hospital for a stroke. So he has many health issues that he's been trying to get organized around. So he does understand that he missed it. He understands that those are his responsibilities solely, but he's asking the court for an opportunity to continue on probation despite this new issue.
So you're saying, let me, just one moment. So he missed reporting on March, what date of March?
26th, it's a Tuesday, Your Honor.
Okay, so he missed reporting on March 26th. And then when did he report?
He reported the 1st, but in between that, Your Honor, he spoke with probation officer on March 28th, that Thursday. They informed him that he needed to be there by 5 p.m. He could not make it. He did make it that following Monday. And I believe a warrant had already been issued.
All right, probation.
Yes, Judge.
So did he call them and let them know that he's homeless?
Judge. There was a telephone call that he felt to report on the 26th. So the telephone call on the 28th, doesn't say anything about him being homeless or anything like that. The notes indicate that the officer told him to be at the location in person by 5 o'clock. Due to him not reporting the prior, a couple days prior.
All right, so Mr. Bolden, here's where we are, and maybe you can tell me something or your counsel can tell me something that will make me think differently. You're here on a failure to register. So that means that you are now on notice that you have to report and you have to register, right? You're supposed to report. Everyone here agrees, your attorney agrees, you agree, probation agrees, states agrees, that you're supposed to report on March 26, 2024. Correct? Did you call probation on March 26, 2024? They don't have that.
I called him called my probation officer on the 26th. I had to, because let him know that I didn't make it in. He told me to contact, he said, contact, police.
Let me do this. Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Jonathan Bolton.
All right, and I'm assuming nobody's objecting to hearsay because I'm trying to get to the bottom of this story.
No objections.
All
Okay.
right, so what happened?
I called him on the 26th and said, I didn't make it in. I'm trying my best to make it in. I'll make it tomorrow. He said, you need to, because they want you to be there to register. I said, okay. So I called them. They said, you better make it in then. I tried my best to get money to get the bus to get out and make it. I could make it. So I called, but I called him back on Friday because the place was closed on Friday. So I called my probation officer back Friday and told him that, he said, I better make it. That's all I told him. That's all.
All right, so this is what I'm not understanding. You called them, you're telling me you called them on March 26th?
Yeah.
All right. And you told them you were not gonna make it,
I told him I'm trying to make it.
okay?
And I told my.
And you
probation-
didn't, and you didn't make it on the 26th. So then they reschedule you for March 28th to give you a chance to make it, and you still didn't make it.
No, they didn't reschedule me. I told them I called. I called the 27th. I called the 27th because it was closed. I called the 27th and told the sergeant down there that I'm trying to make it. I don't have a way of it. I'm trying to get the money to catch the bus. He said, well, you better make it. That's when I called him back on the 28th and told him what that officer said. And I did all I could do, and then I sat in there early Monday morning to try to look it solve, fix it.
Well, see, here's the thing. And correct me if I'm wrong. I'm fine if you correct me. I don't take it as a sign of disrespect. You knew you were supposed to report on March 26th. You didn't report. You say you don't have bus fare. You can't get there. You didn't report on the 27th. And then they tell you you need to be there on the 28th by 5.
27th. That's when he told me, he said, you better get down here.
All right,
I
so-
couldn't do it. I didn't wait.
I don't know what I'm supposed to do with this because he was supposed to report. He didn't report. It's a lifetime registration.
Excuse me, Judge. Out of all the hard times I've had, living in that field, moving in and out, with medical things, they want me to move my stuff. Even when I'm medical hurt and I'm not able to. I mean, it's a big job. I'm right now coming out of that situation. I can be on, you can put me on no tolerance, period.
See, here's the thing. That's what everybody says when we get to this point for a motion to revoke. I have people who tell me, you know, you can keep me on probation for life. You can do this or that. The problem is you haven't been reporting, and this is not your first motion to revoke.
Because I've been having trouble getting it before. I was on, when I got put on, I had to show there every week. I had no problems with the first 15 years. I had no problem because I had a job and I had got away. I have not had no source of income whatsoever. And I'm finding myself having problems. It's not that I don't want a problem. Register or go register. It's a problem I can't. I have trouble getting there. I'm not trying to display attitude that I don't want to do this stuff. I do want to be accountability for myself and for the things I do. It's just the money situation keep me from doing it. I'm not trying to blow it off. It's a no.
All right, just have a seat. I'll take this matter up in a moment. I need to think about some things. All right, who's the person here with the NRA matter of the state of California? All right. All right, is this complainant in custody or no? I mean, is the witness in custody or no?
No, so they are not in custody now.
All right, so what needs to happen is there needs to be. He needs to have an attorney appointed here because this is sort of like an out-of-state subpoena, correct?
It is not a state subpoena, Your Honor. Yes.
All right, so that person needs an attorney appointed to them. And do you have contact information for the persons?
We don't have we have their address, so we were basically gonna have our investigator serve that person and then come to a hearing here whenever y'all had time to do a hearing. It would be a really quick hearing, obviously.
All right, Norma, what date can we have?
Not
Okay, just give me a date. All right, we'll set it on the 30th.
Thank you, Judge.
All right,
What time?
we can do it at 9.
Okay.
All right, who's a defense attorney here who's handled out-of-state subpoenas for out-of-state witnesses? Thank you, Brian Powers. Here you are, Norma. I used to do this all the time. All right, so if you'll get with Mr. Powers, so he'll know the address for his client and he can let his client know that they're serving him.
Certainly. Thank you.
You're welcome. John Narano. Who's the attorney for John Narano?
Here yours.
All right, if you all would come down. All right, what's happening with this case?
I was waiting for an offer. I don't know why it's up. I didn't put it up there.
Okay.
I'm still waiting for an offer from.
All right, just have a seat. They're not ready on that case. Eric Cantu.
Present here, Judge.
Hello.
Come on up.
All right, so the question on this case is there attorney?
State's still diligently trying to find somebody. I believe they've tried with Atascosa, Medina, and I still think they're looking.
The judge, that's accurate. I mean, been doing this almost,
Okay,
so sorry about that. But my understanding is Scott Roberts, Chief of Appeals, is in the process. My understanding of the process, just to let the board know, started late last week.
okay,
And I know that I had turned it over to him, but nothing had been done until then. But he has reached out to 4 different counties, including I think Medina, also Kendall, and then also Atascosa, and I believe one other one. And so he's in that process. The state would just be asking for a little bit more time to get those answers from. I know that Medina said no, and I believe through Mr. Powers, I think that the first is also saying no. So we are waiting to see who will say yes.
all right, so this is gonna be the last setting for you all to have an attorney. I read the motion. I don't. I'll keep an open mind about the motion, I'll say that. But you are gonna come back on June 24th. On June 24th, I'm gonna hear the state's motion.
Thank you, Judge.
Understood, Your Honor.
And once you all sign the reset form, you excuse.
Thank you, Judge.
Thank you. And thank the client for dressing appropriately for court.
That's a good point. He's June 24th.
Yes.
Thank you.
Gabriel Achartia. Hey, have you had a chance to confer on this?
Yes, I have. That's when I'm ready.
All right, so what is happening?
We have an offer, Your Honor, and I have discovery. I would like a date for him to consider the offer.
How old are you?
I'm 20 years old.
All right, Ms. Ferguson. Can you set this case in the second week of June? I'm sorry, third week in June? For plea deadline date? All right, we're gonna come back on June 17th. That will be your plea deadline date. At that time, you need to let the court know whether or not you're accepting the state's offer. You understand?
Yes, Your Honor.
All right, thank you. And I promise next time I'll know how to say your name better.
All right, thank you.
All right,
Thank you, Your Honor.
you're welcome. All right, Victor Ruiz.
Yeah, that's that.
Yes, thank you. Hello.
Hello.
They tell me you're doing great at your employment.
Yes.
Right.
So Judge, the issue or the concern and why you wanted a compliance hearing for Mr. Ruiz was there was an extension status report sent in on his case with the only things that are not completed at this point is his 248 community service hours and the balance he owes on his account that also includes no restitution.
All right. So you need to complete your community service hours. You understand? Whether or not you're extended, that's completely in your purview. You have to complete this community service hours,
Judge,
or I'll allow you to pay them off. Yes.
Judge, the allowance of paying them off option would be great, as well as he is a father. The youngest kid that he has is a year and a half. I don't see that parenting classes were assessed to him during his plea for probation.
Because somebody else did the plea.
Okay, wondering if the court would possibly allow that.
All right. What I'll do then is I'll alter and amend to include parenting classes. And once you complete the parenting classes, your community service hours will be satisfied. I always like for people to do community service hours. One, people find that they end up enjoying community service hours, but then I always want people to do community service hours that maybe can benefit them personally. Because when you give back, hopefully good things will come to you. So parenting classes is something everybody always needs. So if you complete the parenting classes, I will deem that your community service hours are satisfied. We're gonna need to extend you for that. And how long do you think it will take?
Judge, the extension that you actually signed was for a year. I would ask that once his parenting classes are complete, possibly that we can reapproach.
All right, so you'll be able to reapproach. And on that day, you're gonna have to do a UA for me, you understand?
That's fine. No problem.
Okay. All right, do you have any questions about anything else? All right, keep up the good work. All right. Court is calling 2024 CR 0194, State of Texas versus Juan Garcia. Counsel, you're on this side. And could I, Zach, or,
Yes.
oh, continue to confirm. Okay. All right. All right, could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
David Dilly, Your Honor.
And are you Juan Garcia?
Yes.
All right, we have an interpreter here. Could you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and from Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Mariana Rios.
And counsel, do you speak Spanish?
I do, Your Honor.
And do you speak Spanish fluently?
I do, Your Honor.
And were you able to communicate with your client in the Spanish language?
I was, Your Honor.
Mr. Garcia, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
See,
Yes.
And probation, there's no application. Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
see,
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
The state is going to waive count one. State will also be waiving the enhancement language and only proceeding on count two.
Any objection?
No objections, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
see,
Yes.
Did you understand you're charged in count two with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
see,
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
see,
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
see,
Yes.
Did you understand by entering this plea, you were giving up those rights?
see,
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe that he's currently competent and was legally sane at the time of the offense?
He is and he was, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no,
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
see,
Yes.
Are you a U.S. citizen?
see,
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
see,
Yes.
According to the plea, state is proceeding on count two. Punishment is to be assessed at 2 years in the state jail facility. The state is taking in consideration 2024 CR 0186, County Court Cost number 628350. Did you understand that to be the plea?
see,
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
see,
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
see,
Yes.
Counsel, have there been any such motions?
No motions, Your Honor.
Then to offense in count two, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State offer states one and attachments.
No objections, Your Honor.
All right, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
see,
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Just one moment. All right, is there anything you wish to say on behalf of your client?
Yes, Your Honor. So my client has been in custody, in federal custody, actually. He's brought over from federal custody. He was sentenced to 6 years. He's been in custody since October the 14th, 2021. I believe the clerk of the court may have calculated the amount of time credit that he currently has. And so we respectfully request, and I have a copy of the judgment from federal court, going to present it to the court.
Yes.
That shows the date of the offense. I also have a docket sheet from the criminal case if the court would like to see it, where it indicates that my client has remained in custody since the date of his arrest on October the 14th, 2021 to the current date. My understanding is he has a total of 952 days credit if the court permits the same.
All right. Yes. All right, this is what the court will do. The court will find you guilty, sentence you to 2 years in the state jail facility. Give you credit for any time served. This will run concurrent with federal court number DR 21 CR 01800. And the court will give you credit for any time that this case was pending, that you were in federal custody. The court will take into consideration 2024 CR 0186 and 628350. There's to be no contact with Jose Alberto Celestino Ferrero, Fiero. Is there anything else with regards to sentencing from either side?
Nothing from the state, Your Honor.
None for the defense, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, and state, if I can have that, you're working on that?
Absolutely, yes, Judge.
All right, we can go off the record. Here's the thing. You can't build your happiness off somebody else's misery. Stop stealing. You need to ask yourself, truthfully, is days in your life in custody worth stealing somebody's vehicle? You're gonna look up and half of your life is gonna be gone and it's gonna be spent in custody. So you need to start doing better. All right, good luck to you.
Your Honor, may I have the excuse?
Oh, they're gonna give you the dismissals.
We'll do your, I'll hang around.
All right, thank you.
Thank you.
Hi. Always dressed appropriately for court. I appreciate that.
Yes, thank you.
So I got this second motion for access to physical evidence. What's going on?
What's going on, Judge? Essentially, we've got there is a flash drive that is basically the, for lack of a better word, the memory stick for the Tesla
Mhm.
that was involved in this accident. We've gotten some downloads from it, but there is a significant piece of time and video that is missing from what we've been produced in discovery. And we believe it's exculpatory. We've asked the state to provide that to us. We have not gotten it. We asked them to produce the actual stick itself so that we can inspect it. They will not agree to do that. So what we're asking the court to do is to allow us to inspect and or copy, if we need to, the actual stick itself.
All right, so who is saying that what's on the stick and what's been handing over is not the
We-
complete?
We are, Judge. And
All
the
right, is
re-
it you or your expert?
Judge, this is a really simple, cursory examination of what we've got. We've got a period of time that leads up to the accident. We've got a period of time that shows the passenger getting out of the car. And then the video that shows my client getting out of the car is missing.
All right,
And then we have video after that time. So there's definitely a gap.
all right, so state, do you know
Judge,
about this gap?
Yeah, this has been with Daniel Escobar, and it's been a process, but, what my understanding is at first, the SCP turns over whatever they have. And then it went through a process of that there may be something else additional on there. And then they were gonna send it to us, but then they wanted defense, I think, wanted the original, or whatever purposes, obviously chain of custody, things like that, we couldn't do that. And then what we found out is that last week during the murder trial, we actually got, my understanding is the SAPD now chain of custody over to a company, ROCIC, to actually have the original to hunt it down. And they're supposed to be taking it over there. And I don't know if they took it over there last week or not, to process it to see if they can pull anything else off of there. So that's where we're at currently.
All right, so this organization who's taking it to process it, are they in Bear County?
I have no idea, Judge.
I don't know exactly the process that they're doing. Again, I mean, I was sort of on doing other things, I guess. But I mean, I could get it with Daniel, he's in Impact right now, but to find out exactly what's going on with that, but it'd be us having to contact, because one of our investigators here at the DA's office, Doyle, that used to be with SCPD, has actually been an intricate part of working with them, of trying to get the actual USB drive or whatever it may be over there to get it processed.
All right, so why don't we do this? Why don't we set it for a hearing, and whoever that company is, see if they can zoom in. And if your expert can be here, and we'll see if they can turn over a copy or some kind of way, send a copy of what they're saying is on the entire stick to your expert, or either if your expert can go to their facility.
Okay.
I think that would solve the problem, and then your expert can say, this is not the entirety. And then if it turns out it's not the entirety, then of course, I'll make my ruling. But it appears to the court that the state is trying to extract everything. So they have a new company who's doing it.
Judge, if I may, just for the record, express my frustration with the process, because when we originally got the
Oh, I
discovery.
know, we've been waiting on this video. I've had us going on this video since January, so I understand.
And the story's changed like 3 times, and I don't know why it got sent out after we requested to see the actual stick.
Okay, so this is what we're gonna do. Everybody follow along. We're gonna set this for a hearing. That company, whoever it is, they can send a representative by Zoom if they're out of county. Are you okay with that?
I'm fine with that, Judge.
All right, so we can do it by Zoom. What I'm gonna wanna know from them, one, are they able to extract everything and give a copy to defense? Or 2, can the defense's expert go to wherever their company is to get a copy of it, or at least view the extraction of it, so that your expert will say, this is everything? That's what we're gonna do.
And Judge, if I may, and I'm sorry, but I kind of need to insist on this, as you know, attorneys, we trust, but we need to verify.
Yeah.
My expert needs to see the original at some point.
That's what I'm saying. We're gonna make that happen. So we're gonna have the hearing. Because I know sometimes companies say they're super busy. If need be, the expert for the state can appear by Zoom. If you'll have your expert here either by Zoom, who knows? Maybe your expert can be by Zoom, the other person can be on Zoom. I will give them co-host duties. They can go in a breakout room together. You all can go in a breakout room with them and discuss what information you feel your expert needs. And then we can make it happen.
That sounds fair. Thank you, Judge.
All right, so next question. I know Daniel's in impact court. So if we reset this, what date is good for you, counsel? Because I know you have your other employment.
Pretty much any day but Tuesdays. Other than that, I can make it happen.
All right, so if we put this the week of June 24th, is that enough time, State, for Daniel to
June 24th.
that week of June 24th?
I could say yes.
All right. So this is what we'll do. We're gonna set it for the week of June 24th, but counsel, if you'll talk to Daniel, because he's the person who's over the case and he's in impact court. I'm sure if you'll talk to him by next week, to see if that's a good date for him to get all the information and for us to set it up by Zoom.
Okay, I
And-
think the only day I've got available to do that, Judge, is the 26th, which would be that Wednesday. I don't know if that jives with the court's calendar.
Let me ask you this, what about? I know the first week in July, I try to give people time off.
And I'm gonna be gone literally from the 28th through July 12th.
Okay, July 12th? Let me look.
So that puts us in like third week of July.
Well, you want to do it the week of July 22nd?
That would be perfect. I can do that Monday if we wanted to.
All right, so we're gonna do it Monday, the 22nd. And Mr. Castillo, you can appear by Zoom as well. Are you employed?
Yes, ma'am.
All right, so you can appear by Zoom if you want to appear by Zoom. This is just, well, it's probably going to be something, if they don't come to an agreement, that may need to be on the record. So if you want to appear by Zoom, you can appear by Zoom.
Yes, ma'am.
All right. So we'll put it for July 22nd. And counsel, if for some reason there's some issues with that video, we'll cross that bridge and I'll make an appropriate ruling.
Thank you, Judge.
You're welcome.
Appreciate it.
The other thing. You said you wanted, funds, more funds. I have this.
It's not for the,
It's about the video and it's about funds.
yes, Your Honor.
And since you didn't do it ex parte, so. If you can put in, because it's not in the order, if you can put in, you know, who it is so that the auditors can pay.
I think it's gonna be Leviticus.
All right, so if you'll fill that in,
I can't-
and also if you'll fill in, what the amount will be.
Okay. Do that, Judge.
All right, you can have a seat. They're gonna give you a reset form for, July 22nd, okay?
Yes, ma'am. Thank you.
You're welcome. All right, court is calling 2024 CR 3973, State of Texas versus Perfecto Escobedo. Can I have parties announced for the record for the state
Is that done for the state?
defense?
Elizabeth Russell from Perfecto Escobedo.
All right, this hearing was scheduled at 9 a.m. and it's now 10:49 a.m. The defendant did not answer the docket and the defendant has not made an appearance. Deputy Laura, does it show that Mr. Escobedo is in custody?
No, Your Honor, he is out on bond, but he does have a warrant.
All right, defense, have you had any contact with your client?
I have it, Your Honor, and I'm not sure I'm appointed to the MTR yet.
Okay, and I just called the new case.
Okay.
So have you made attempts to contact him?
I have, Your Honor.
All right, state?
The state would respectfully request a bond forfeiture.
All right, that would be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Okay, thank you, Judge.
Thank you. All right, counsel, do you have all the discovery?
Yes, ma'am, I do. I have all the discovery and I'm asking for a firm trial date.
All right, has an offer been tendered?
Yes, ma'am, we discussed it extensively.
Mr. Salas, are you rejecting the offer and requesting a jury trial?
Yes, ma'am.
How long are you expecting this trial to last?
Oh, I think it's a 3-day endeavor.
All right, Ms. Ferguson. Can you give me a jury trial date on Mr. Salas? And it's 3 days. All right, August 12th, and you will be in impact court and you'll be dressed for trial. Your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Do you understand?
Yes, ma'am.
He comes over to impact court dressed for trial.
Yes.
Thank you, ma'am.
You're welcome. All right, Claudia, Aaron, Norma, do you know what the case the attorney is trying in Kamel, how long that's gonna be?